It's either the very first piece of evidence introduced or it's damn well close to it.
We're the Armed Attorneys. We're on a mission to make life for the law-abiding gun owner just a little bit easier by sharing fast and factual gun law information. Today, we're talking about the kind of 5 critical steps that comes to making a 911 call following a self-defense incident. And you're going to want to stick around to the end. We have kind of our attorney pro tip of the day, defies conventional wisdom and what a lot of industry experts are saying, so you won't want to miss it. But before we begin, show your support for the Second Amendment by hitting that like button. To start things off, we're assuming that our scene is safe. You've stopped a threat, and now we come to that critical 911 call. Emily, where do you start with your clients?
Yeah, and this is one of the most common questions I get. What do I do after I've shot someone and I know I have to make that 911 call? What do I say? And so here we go. I mean, I think that we have to start by saying there's a little bit of disagreement, even amongst Richard and I. And the reason that we disagree is that we've all tried different self-defense cases, and you want something a little bit different from each case, because this 911 call is going to be probably State's Exhibit 1, right? I mean, it's either the very first piece of evidence introduced or it's damn well close to it. Yeah. So it's got to be tight. It is recorded. And I think the first thing we have to say is it's recorded from probably the second the phone starts ringing, not when the dispatcher picks up. That's not true in every jurisdiction, but you must assume it's true in yours. Don't be that guy who says, "I'm glad he's dead," as the phone's ringing before the dispatcher picks up, because there's a good chance that's recorded and that's evidence.
And that brings us to kind of the first critical step, which is, you've called 911, providing your name. They got to know who they're talking to. The second critical step is providing the location of the services needed. Now, this probably needs to be repeated. I spoke to many dispatchers. They say, "Hey, will you please convey to your people that they need to repeat the address?" Because, you're hyped up on adrenaline, but confirming the location where the service is needed. The third critical step is what services are needed.
And by the way, you always want police and EMS. I don't care if you think you're injured or not. I don't care if you want that guy to survive or not. Always ask for EMS. You don't know that you haven't been injured. Also, I mean, it's nice for your attorneys in court to argue he didn't want him dead, right? He called for EMS as well. He just wanted to stop the threat, keep himself safe. He didn't want anyone to die.
Exactly right. The fourth critical step, and this is where Emily and I disagree, and we'll talk about this a little bit, is giving a short statement about the defensive incident. Now, I'm of the mindset that the kind of best short, truthful statement about the defensive incident is something along the lines of, "Hey, I was just attacked and I was forced to defend myself." That could be somebody tried to kick down my door and I defended myself. Somebody tried to rob me and I defended myself. It could come, but it needs to be a short, truthful statement about the defensive incident. Now, there's pros and cons to it, but what do you tell your clients, Emily?
Yeah, so, and I disagree, and this is something I think all of our attorneys probably want something a little bit different. It is something that we do tend to disagree on. I want that short, truthful statement to be only about what the bad guy did to you, not about how you responded. And the reason being, I mean, there's just some human psychological factors involved. When the police know that you have responded aggressively, violently, that you've shot someone, they are going to start that investigation in a much different way than if they get there on scene just thinking that you're only a victim. Now, they're going to figure it out very quickly, and hopefully by then you've talked to an attorney, you have some good defensive statements ready to go. However, it just is, in my mind, and of course, bear in mind, the prosecutor is going to use it against you either way.
Exactly right.
In my mind, it's better to just frame it as what the bad guy did to you. And then once you've talked to an attorney and police are on the scene, you talk about your defensive response. Prosecutor is, I've tried cases where, he attacked me and I had to defend myself. And the prosecutor lays out very persuasively why, that sounds staged for this reason, that reason. He's already, he knows he messed up and he's already trying to cover it up. Whereas in, Richard's point as to, my advice is, if you don't say anything, they're going to use that against you.
Yeah, no matter, as Emily said. And what we're talking about, the difference between our two statements are, one saying I was attacked, one is I was attacked and had to defend myself. So we're not talking about that too big of a difference, but the advantages to Emily's, kind of strategy is maybe the police have lower adrenaline when they arrive. Maybe their investigation proceeds differently. The pros to maybe my approach is it establishes a defense that you see in courts and jurisdictions all across the United States. In most cases, you have to raise some evidence of acting in defense in order to be entitled to a jury instruction on self-defense or defense of others. And so maybe that 911 call serves as that critical piece of some evidence that gets you that instruction
It could keep you off the stand.
Yeah, without having to testify. And so there's pros and cons to both, and it's going to be very situational. You know your jurisdiction, your prosecutors, your police better than probably anybody. And so it's just going to depend. And so that's our fourth critical step. So to review: name, location, services needed, police and EMS, our short, truthful statement, whether that's I defended myself or I was attacked, whatever that sounds like. And the next critical step is hanging up the phone. Now, we've heard some talk online about E911 locking phones down, making them to where they can't disengage. Whatever you need to do, the phone needs to go off. It needs to go in airplane mode. You need to hang up the call. It's not a crime to hang up on 911. Let's say they lock a phone down and you can't do anything with it. It needs to go in another room where it can't be gathering or listening on to any more conversations. And the next critical step is that you're talking to your attorney. Now, have you ever, I haven't had a client have E911 engage.
I'm not entirely certain that it isn't like a really successful urban legend. You always hear, it happened to someone else. It happened to a friend. It happened to my cousin. I've never spoken to someone where it actually happened to them. And I've talked to some dispatchers in our area, and none of them have ever seen such a service. But who knows?
But let's say you do have that happen. Phone goes in another room. You're using another telephone to call your attorney. That's what you would need to do. But that kind of brings us to our attorney pro tip of the day, which is I think is going to be a little bit controversial because there are a lot of industry experts that I know will disagree with us. And that's about providing your description on the 911 call itself. Now, having spoken to many dispatchers, police, and being a prosecutor myself, this is kind of our reasoning behind not providing your description on the 911 call. When police are receiving information from dispatch, 9 times out of 10, I bet you it's even higher than that. I bet 19 times out of 20, they're giving the description of a suspect. They're not giving a description of a victim.
It's the bad guy.
It's the bad guy. And so on this psychological, maybe it's even on a level where they're not registering it or doing it consciously. If you're providing your description to dispatch is forwarding that to patrol officers. I think it will have some subconscious effect on officers arriving on scene. Maybe they investigate the crime just a little bit differently because subconsciously they've received that description. They associate that with a suspect. And so for that reason, we don't advise people to provide their description on the 911 call.
And if you think these subtle psychological things with officers we're talking about is kind of a silliness, don't. That officer who, frames your situation, writes that report, decides how to frame it to the district attorney, can make or break you. And so it really is incredibly important. But with all that said, thank you for watching. If you've enjoyed this content, please consider subscribing, and let's all fight the anti-2A algorithm by sharing this video.
And we always enjoy your comments and questions in the section below. And until next time, we're the Armed Attorneys.